Please be seated. We will swap.
The status conference on the case against Deputy President William Ruto and journalist Joshua Sang did not end conclusively on Friday. And so today, the prosecution and defense teams, as well as the victim's representative, presented further arguments regarding the question as to whether witnesses could be compelled to appear before the court.
The power to require the attendance and testimony of witnesses is a power fundamental to a criminal court in any jurisdiction in the world. An ICC trial chamber must exercise this power through the cooperation of states parties, because that's how the Rome Statute is structured, based on concepts of complementarity and state party cooperation.
There is no power of coercion. Witnesses must attend voluntarily.
Mr. President, if you were to insist that you have powers to compel a witness, it would require you to struggle and explain away the use of the word require and replace it with the word order. And Mr. President, we maintain our submissions that we made originally, that when the drafters used the word require, they deliberately chose not to use the word order, and it cannot be read that or implied that it was lack of consciousness that they used the word require as opposed to order.
There would be no logical reasoning in law if it were possible to compel a witness in respect of a very light offenses, and not be able to compel in respect of offenses which, as they say, shock the conscience of man.
It doesn't matter if there's a sanction or not in the Rome Statute.
If a witness today is in the witness room and the witness declines to come to court, Your Honours do not have the power to bring that witness by force to this seat. You do not have the power. There's no statutory article, there's no penalty, there's no power of arrest. Even on these inviolable premises, with an ICC security, if such a witness was strong-armed, that would be an assault, or it would be false arrest. So, Your Honours, if the court does not have the power to do that, upon what basis can the prosecution say it can compel a third state to do something which is not required under its own domestic law?
The prosecution, however, alleges that witnesses in question did not just recant their testimonies or withdraw from the case. Trial lawyer Anton Steinberg claims they have evidence of intimidation, bribery or improper influence, which they believe caused each of the 7 witnesses to stop cooperating with the office of the prosecutor.
One might say that recantations made in the media are cheap. To do so under under pain of perjury is a different matter altogether.
Steinberg furnished the trial chamber with details of the said unwilling witnesses.
At the outset, it should be noticed that only 3 of the 7 witnesses have in fact recounted their earlier statements. In regard, that is witnesses P15, P16 and P336. In respect of the remaining 4 witnesses, they have simply refused to testify but have not disavowed their prior statements. Thus, there is no reason to believe that if their attendance may be secured, they will not confirm their earlier statements.
Both the defense and prosecution teams, however, agree that it would be important for the witnesses to appear before the court in order for the chamber to determine whether several important prosecution witnesses are part of a deliberate and concerted scheme to cook evidence against the accused, as the defense alleges, or on the contrary, there exists a deliberate and concerted scheme to intimidate witnesses or corrupt prosecution witnesses to recant or withdraw their testimony, as the prosecution alleges. The prosecution team, however, says the statements of 5 out of the 7 witnesses were audio recorded as a safeguard against any improper influence. After listening to the various arguments regarding the compellability of witnesses, the chamber did not immediately make a ruling, choosing instead to usher in the 11th prosecution witness, Yves Maupeou, a French national who was apparently in the country for some time in 2007, but left when violence erupted.
Alors, je déclare solennellement que je dirai la vérité, toute la vérité, rien que la vérité.
And just for the record, I want to make it clear that the prosecution is presenting this witness as an expert in matters of social and political background information regarding Kenya, part of the post-election violence and during the time relevant to the charges.
The trial continues for the next 3 weeks before taking another recess according to the court schedule. Sylvia Chebet for Monday Special.